Good afternoon, everyone, and welcome to our fourth instalment of the Women in Planning Lunch Bites webinars. My name is Mandy Gill, and I'm the chair of the Women in Planning West Midlands Committee. This is our first event of 2022, and this event marks our 10th birthday. Thank you to all our members for attending and offering to speak at our events. Together, we will empower all women and increase equality in our industry. Today's session is led by Rachael Coulsting, Grace Mitchell, and Jill Briggs from Shoosmiths. Rachael and Grace are both senior associates in the planning team at Shoosmiths and will speak to you about the implications of biodiversity net gain and nutrient neutrality on planning applications and the issues that developers and local authorities need to consider in order to secure compliance. Jill is a principal associate in the real estate team at Shoosmiths and will highlight the impact this legislation is likely to have on residential development from a land perspective. This session will last 30 minutes with a 15-minute Q&A opportunity at the end. As usual, if you have any questions, please do note them in the Q&A function, which you can access on the bottom right-hand side of your screen. And if we have time at the end, we will try and pick these up. This session is being recorded and will be uploaded to the Women in Planning YouTube channel. I will now hand over to Rachael.
It's actually me going first, but hi everyone.
Sorry.
That's fine, don't worry. So I'm just going to talk about biodiversity very generally and the impact that it will have on residential development. So for those of you that don't know, biodiversity is the biological variety and variability of life on Earth. In very basic terms, the more biodiverse the planet is, the better. That applies to both animals and plants. In recent years, there have been huge biodiversity losses globally. At a macro level, it's now on a par with climate change as one of the biggest challenges facing the future of life on Earth. Boris Johnson recently stated that tackling climate change and biodiversity loss is the government's #1 international priority. In many ways, they go hand in hand with one another. But how is this relevant to house building and what can our industry do about it? At a very basic level, we all rely upon biodiversity. Without plants, there wouldn't be any oxygen. We rely on bees and other species for pollination, and trees are very effective at removing carbon dioxide from the atmosphere. It's more than that though. Jeremy Clarkson noted in his recent hit show Clarkson's Farm that if you take a drive in the countryside, you have far fewer dead insects on the windscreen than even 20 years ago. Now you might think that that's a good thing, but it's a simple marker that biodiversity is being threatened. Therefore, every time we dig up a field, clear marshes, cut down trees and build houses in their place, we risk damage to biodiversity. Urbanisation is considered to be one of the key causes of species decline in the UK. The government's reaction to this has been to introduce planning legislation so that the impact of development on biodiversity is considered at the earliest stage of the process. Put bluntly, unless house builders can show that they've taken steps to provide net gains for biodiversity, they're unlikely to get planning applications approved. The Natural Environment Act will introduce an obligation to enhance biodiversity and for development to deliver 10% biodiversity net gain, i.e. the biodiversity metrics pre-build must be exceeded upon completion by not less than 10%. In this way, biodiversity is being addressed through planning as a cost of entry to residential and other development. Housing development impacts on biodiversity in a number of ways. The obvious is on-site disturbance. We've all come across developments which have been delayed due to newts, orchids, badgers or bats, for example. However, less obviously, development may impact off-site habitats due to disturbance, displacement and air and water pollution. For example, noise and light can impact feeding and breeding behaviours and cause ecological displacement. And land clearance for development can upset natural flood defences as well as disrupting habitats for wild birds and animals. The intention is that planners and house builders work together to minimise the impact of developments through good design and thoughtful layouts. The NPPF requires a proactive approach to mitigating climate change and the effect of a development upon biodiversity. Prior to submitting a planning application, developers should be screening for the likely impacts of their works on biodiversity and determining the need for a biodiversity net gain assessment. DEFRA has put in place a net gain biodiversity metric calculator, which will identify the scale of impact of the development and provide a gauge for the measures which will need to be taken to secure a net gain in the final development. The calculator will inform house builders as to how much credit their designs provide, and this will then enable them to budget accordingly. Not only will biodiversity become a cost of entry to the development process through planning, but it will also be an ongoing cost of operation following development delivery, and it may even represent an opportunity to differentiate developments in a positive way, enhancing value for developers. On a practical level, steps which can be taken include installing hedgehog highways to enable them to move safely around a development, providing bat boxes and designing bat-friendly lighting, the use of sustainable drainage systems, the introduction of more soft landscaping, and the retention, reinstatement or establishment of hedgerows instead of using fencing. Interestingly, over the weekend, I read that Brighton and Hove Local Authority now require all new homes to be constructed with a bee brick in situ, and I was reading yesterday that Prince Charles is taking an avid interest in our hedgerows. Developers will be expected to arrange for the monitoring of existing, restored or newly created habitats and landscaping, and to compensate for loss of features by recreating them, restoring habitats and creating buffer areas to reduce the impact on neighbouring areas. Net gain measures will need to be monitored for at least 30 years after establishment, but ideally the obligation should be permanent. One direct result of the COVID pandemic and the resulting lockdown has been more of a demand for the public for green space and nature-rich environments. Therefore, in protecting biodiversity, not only will the house builders be more likely to have a smooth journey through the planning process, but they'll also create a more pleasant environment for consumers to live in, which in turn will have an economic impact. If publicised correctly, the steps taken by house builders to offset damage to the environment could be turned into an effective marketing tool. After all, who amongst us wouldn't prefer to have views over a wildflower meadow rather than a concrete car park, or wake up to the sound of birdsong rather than the noise of cars rushing by? The actions taken do not necessarily need to be costly, and they don't need to have a huge impact on plot numbers, but not considering biodiversity is no longer an option. Indeed, there are potential cost savings. Such, for example, often have lower installation and maintenance costs than hard engineered solutions. Green space with integrated SUDs would help to reduce flood risk, provide clean runoff water, take up carbon from the atmosphere and filter pollutions. Additionally, this provides a much more attractive feature than traditional drainage systems. This legislation also provides opportunities. If sufficient credits cannot be achieved within the boundaries of a development, there is the ability to go off-site and to trade credits owned by another landowner or a developer. As biodiversity net gain becomes mandatory, it is possible that, for example, a developer which has set aside a large area as a SANG could sell off areas of that SANG to assist in smaller developments, complying with the environmental legislation in a way that might not otherwise be possible. Additionally, this is an opportunity for the construction industry to change its image. House builders are an easy target for the press and have often been portrayed as greedy and heartless. Constructing developments which are attractive and environmentally friendly and engaging in projects which help the environment and in turn the community can only lead to positive publicity. Biodiversity net gain cannot be ignored. The earlier in the process that it is addressed, the easier and less costly it will be. Those in the industry who embrace the legislation at the earliest opportunity will have a much easier time of it. And now my colleague Rachel will be discussing the implications of this from a planning perspective.
Thanks for that, Jill. And hello, everyone. As Mandy said at the beginning, my name is Rachael Coulsting. I'm a Senior Associate in the Planning team at Shoosmiths in Birmingham. I just want to apologise in advance because I've currently got both of my children at home isolating due to COVID. So if you see anybody wandering about in the background or hear any background noise, then that's what that is, but hopefully they'll behave themselves. So can I have my first slide, please? Thank you. So today I'm going to be covering biodiversity net gain in light of the recently enacted Environment Act 2021 and looking at the impact it will have on planning applications and decisions, as well as some practical tips for developers and also some points for local authorities and landowners. I'll then finish by looking at the key issues arising out of the recent DEFRA consultation. Next slide, please. So what is biodiversity net gain and why has it all come about? And thanks, Jill, for that introduction there. I don't want to spend too long on this section because I want to get into the details of how it will work in practice. But the overall context of this is COP26, which, as you all know, took place in November last year, and a renewed focus generally on climate change and the natural environment, and the need to assess the impact of development on the environment. and to avoid, limit or mitigate against adverse effects. Next slide, please. So there's always been a focus on this in planning, and local authorities are already under a statutory duty under the Natural Environment and Rural Communities Act 2006 to have regard to conserving biodiversity in exercising their statutory functions, including in plan making and decision taking under the Town and Country Planning Act. And government policy on how local authorities should discharge that duty is set out in the NPPF and planning practice guidance. And looking at these in turn, the NPPF paragraph 174 includes a requirement that planning policies and decisions should contribute to and enhance the natural environment by providing net gains for biodiversity. Paragraph 179 sets out the requirements that local plans should identify and pursue opportunities for securing measurable net gains for biodiversity. And finally, paragraph 180 states that opportunities to improve biodiversity in and around developments should be integrated as part of their design, especially where this can secure measurable net gains for biodiversity or enhance public access to nature where this is appropriate. And planning practice guidance contains definitions for what is meant by net gain and what is meant more specifically by biodiversity net gain. And essentially, as Jill stated at the beginning, the aim of biodiversity net gain is to leave the environment in a better state than it was beforehand. An important point is that gains should be measurable, and the PPG explains how net gains can be measured, and this includes using the biodiversity metric published by DEFRA. And this enables calculation of losses and gains based on assessments of the distinctiveness, condition and extent of habitats. And the distinctiveness in this context is a judgment as to whether the habitat is of high, medium or low value to wildlife. And by way of a very simple example, a wildflower meadow would have a much higher value than, say, a car park. The condition is a judgment as to the state of the habitat, and the extent is the area of the habitat. And the metric translates habitat distinctiveness, condition and extent into a score, which is presented in biodiversity units, which represents biodiversity value before and after development. And this provides a way of measuring and accounting for environmental losses and gains resulting from the development. A simplified version of the biodiversity metric has been developed specifically for use on small development sites, and that's known as the Small Sites Net Metric. The PPG expressly states that biodiversity net gain can be achieved on-site, off-site, or through a combination of on-site and off-site measures. And crucially, there is currently no legal national minimum requirement for net gain, although local authorities can include targets in their local plans and policies. Next slide, please. However, the Environment Act 2021, which came onto the statute book on the 9th of November last year, just before the close of COP26, contains a whole raft of measures aimed at protecting the natural environment. And these include a new statutory requirement for planning to deliver biodiversity net gain and measures for how this should be achieved. And if you're interested, these are all contained in parts 6 and 7 and schedules 14 and 15 of the Act, and they apply to England only. However, the key points to make here is that they are not yet in force. They have to be brought into force by enabling legislation, i.e. regulations, which have not yet been made. And the DEFRA consultation that was launched recently, which I'll come on to, will determine what these regulations should cover. Section 40 of the Natural Environment Act 2006 will be amended pursuant to the Environment Act so that the duty of local authorities to conserve biodiversity becomes a duty to enhance biodiversity. And when the provisions are brought into force, the Act will introduce a new statutory requirement for all development, including applications under the Town and Country Planning Act and NSIPs under the Planning Act, to deliver 10% biodiversity net gain. So what does this mean? So it means that the biodiversity value of a development needs to exceed the pre-development biodiversity value of the on-site habitat by 10%, and it's to be calculated using the biodiversity metric. There will be some exemptions, which I'll come on to later. And this will be secured by a new standard planning condition set out in Schedules 14 and 15, which will be a pre-consent condition to submit a biodiversity net gain scheme to be approved. And the scheme will set out how biodiversity net gain will be delivered, either on-site or off-site, and setting out how the gains will be monitored and maintained on an ongoing basis for at least 30 years. The Secretary of State is also empowered to introduce a national system of biodiversity credit in lieu of provision on-site or off-site. And revenue from the sale of credit will be ring-fenced for investment in biodiversity net gain. Landowners can sign up to the credit system through a process known as habitat banking, by which they'll be able to offer up some of their land to be used for biodiversity net gain purposes and will be added to a register. Next slide, please. The Act also makes provision for a new form of statutory agreement called a conservation covenant. And this is an agreement between a landowner and a responsible body relating to the management and maintenance of land for biodiversity net gain for the required 30-year period. And a responsible body would be the Secretary of State or anybody designated by the Secretary of State. This could include local authorities. And if a local authority or any other body wishes to be designated as a responsible body, they will have to apply to the Secretary of State to be designated. Other organisations could also apply to be a responsible body if its main purpose, function or activity relates to conservation. And this could include, for example, the National Trust and local conservation groups. The conservation covenants would be registered as a local land charge and would be binding on the landowner and successors in title. It would also be enforceable by the responsible body through the usual contractual remedies. So conservation covenants could be used by landowners as a means of creating a biodiversity site, securing management of that site by the responsible body, which could be the National Trust, the RSPB, etc., and so ensuring that the site is added to the biodiversity register and is eligible for credits. Next slide, please. So moving on to the key implications of all this, firstly for developers. Clearly, developers will need to be aware of this new legislation and the need to achieve 10% biodiversity net gain once the provisions come into force. And the anticipated timescale for this is currently November 2023, although this could be extended. And it will affect any new schemes likely to get consent after this date. So developers do need to be considering it now. And when planning new schemes, they'll need to consider how this requirements will be secured, either on-site or through off-site measures, which could involve the developer buying a separate parcel of land on which to deliver it, or engaging with a third party and paying them to deliver it on their land, or buying government credits, as mentioned earlier. They also need to be mindful of what the 10% biodiversity net gain target will look like in practice. So when developing out a site, for instance, in a rural setting to provide houses, the act of preparing the site and digging the foundations, etc., will in itself amount to a destruction of habitat and natural environment. But obviously you need to leave the site 10% better off than when you found it. So essentially you've already taken a back step in doing the initial clearance works, which could put you at, say, minus 10%. So in reality, you need to secure through on-site or off-site measures more like 20% biodiversity net gain to ensure compliance. Could this also encourage more development on brownfield land, where there's less green space and habitats are less likely to be destroyed through the build-out process? So it would essentially be easier to meet the 10% target in these areas, noting that the 10% requirement is actually the same regardless of where the development is located. Obviously, there'll be other issues on those sites, contamination, etc., to deal with. Another point to note is how will this, and indeed will this, have any impact on viability of schemes? How much of a hit financially will the 10% requirement have on schemes? And in terms of the credit system, how is this to be calculated? And how much will developers need to pay out? Incidentally, the Environment Act does state that regulations will be brought into effect dealing specifically with the credit system, how calculations are to be made, how much credit should be worth, etc. So will this new legal requirement mean that other areas of mitigation will suffer as they get lower down the pecking order, so to speak, due to viability issues? For instance, affordable housing, although obviously except in relation to providing first homes, which are now mandatory, but it could affect other types of affordable housing, or maybe some contributions, such as library contributions, for instance, might suffer. So until it comes into effect and we start seeing exactly how this will be measured, we just don't know. In terms of local authorities, they'll also need to note the 10% requirements when it comes into force, and they'll be under a legal duty to secure this. And the key point here, and it's important for developers to note as well, is that it's not a maximum percentage. So local authorities would still be able to set policies requiring a higher percentage, provided of course there is a clear reason for doing so and it is reasonable. At the moment, 10% is not yet in force, so we're currently reliant on local plans and adopted planning policy to set or determine the minimum required percentage. And Chris Young QC posted a link recently actually to an appeal decision involving Bloor Homes, in which the local authority hadn't set a percentage requirements in their local plan, and the inspector found that 1% was sufficient in the circumstances of that case. In terms of landowners, they could think about how they might be able to benefit from all this. Could part of their land be used for off-site mitigation? They could sign up to the government's national credit scheme or enter into conservation covenants with a responsible body in order to receive credits from developers who would essentially buy into a scheme on their land, for instance, a proposed scheme to create new woodland, for instance, which would then be assessed and given a credit score, say 10,000 credits, each worth something, we're not sure what at this stage. And then 10 developers could come along and each buy 1,000 credits, and that could result in quite a substantial income stream for the landowner. Landowners can also sign up to schemes, as previously mentioned, through habitat banking, which is being run via bodies such as Environment Bank, to enable their land and the credits that will arise from it to service multiple developments in their area. The Environment Bank would measure the biodiversity units impacted by the development, apply the 10% uplift requirement, and sell conservation credits to the developer. So they essentially manage the process and pay landowners using the credits sold to manage the land for the required 30-year period. I should also note that work is currently being carried out in our Solent office in relation to nitrates, which Grace will cover shortly, where they're drawing up agreements between developers and local authorities, where the mitigation area is outside the administrative area where the development is to be situated, to secure credits for off-site mitigation in relation to nitrates. And we think this could also potentially apply to Biodiversity Net Gain, but we're still in the early stages in terms of this and how it will work in practice, but I'll let Grace cover that in more detail. Next slide, please. Lastly, I just want to cover the key issues arising from the recently announced DEFRA consultation and how this might affect everything I've just said. So the consultation is seeking views in relation to how Biodiversity Net Gain provisions will work in practice, including what the new regulations will look like, whether exemptions should apply, and whether the provisions should apply in the same way to all schemes, for instance, phase developments, small sites and NSIPs. And the consultation period ends on the 5th of April this year. One key point to note in the consultation document, which I've already alluded to, is that the exemption related to brownfield sites has now been scrapped. So brownfield sites will also now be subject to the 10% requirement. And this means that the only exemptions currently being proposed are in relation to developments which will have a minimal impact on habitat areas, household applications, and change of use applications. Everything else will fall within the 10% requirement, although they are also considering making exemptions for developments involving the creation of biodiversity gain sites and self-build or custom house building. Another key point is that there are set to be provisions put in place in relation to phase developments and also outline permissions. And delivery of biodiversity net gain on phase sites will need to be demonstrated across the whole site, with details to be submitted as to how targets would be delivered at each stage of the development. The provision, for instance, if later phases of development are not delivered, the biodiversity net gain to be front-loaded into the earlier phases to ensure the target is met. Also, in relation to landowners signing up to habitat banking, the consultation acknowledges that there is some confusion as to how this would affect farmers' eligibility to apply for other government benefits in relation to the same parcel of land, for instance, agricultural property relief and also business property relief. And it says that work is currently underway to provide clear guidance on this. Of course, all of this isn't scheduled to come out and be in force until 2023, so anything can happen before then. It'll obviously lead into the next Parliament, so will all of this still be an issue? I think almost certainly it will be. It's very much a hot topic at the minute, supported by environmentalists and the like, and I think time will tell once we get the details of the regulations as to exactly how this will all take shape. So that's it for my segment. I'm now going to hand over to Grace, who will be dealing with nitrates and nutrient neutrality.
Thanks, Rachel. I'm just going to check that yeah, can you see me move the slides there? Great, fab. So yes, I'm going to talk about nutrient neutrality. So I'm going to cover what that means and why it's relevant to the world of planning and what we're doing in terms of solutions. The need to achieve nutrient neutrality is currently affecting large areas of southern England. So as Rachel said, I'm based down in the Solent office, so I'm seeing this come up quite a bit, but it's likely to affect more of the country, which is why we're talking about it nationally today. So what do I mean when I say nutrient neutrality and it being an issue? Nutrients, in particular nitrates and phosphates, and I'm mainly going to talk about nitrates today, can be found in agricultural fertiliser and wastewater, and it finds its way into the water system, and this creates eutrophication. So a nutrient overload which causes plant life growing in abundance, algal blooms, and it starves the water of oxygen and then leads to fish and aquatic animals to die. Oh, sorry, I've just been plunged into darkness. There you go, put the light back on. And then it also removes food source for other animals. And this nutrient overload is currently affecting protected habitats, in particular in the Solent on the south coast, but also other special protection areas and Ramsar sites as well. And these special protection areas are designated under EU law under the Council directives, and these invoke the habitats regulations into our law, and this is why it's an issue in the world of planning. So just to give you a bit of the sort of legal background, the key provisions are in Regulation 63 of the Habitat Regs, which sets out that a competent authority, so the local planning authority or Secretary of State, cannot grant any consent, permission or other authorisation for a plan or project which is likely to have a significant effect without having first carried out an appropriate assessment of the implications of the plan or project for that site. But the crux of it is in Regulation 63.5, which you can see I've put on the slide there, that says that this provides that the competent authority, so the local planning authority again, may only agree to the plan or project, i.e. grant planning permission, after having ascertained that it will not affect the integrity of the European site. And European sites are special protection areas under the Birds Directive and special areas of conservation under the Habitats Directive. So in 2019, there was a landmark decision by the European Court of Justice known as the Dutch nitrate cases, and that determined that all plans and projects must be individually assessed and mitigated. It's just worth noting that these cases do still apply even though we've now left the EU, as they were frozen in time as case law under the Withdrawal Act. So the Dutch nitrate cases led to Natural England to issue guidance for the Solent area that planning permission should not be granted for residential development unless it is nutrient neutral. So I've just listed on the slide there some areas that are currently being affected in terms of residential development. And you can see they're all along the south coast, but Natural England have now said that they think the guidance will be rolled out nationally on the basis that these issues are going to start arising elsewhere nationally as well. So what does the guidance say? Natural England first issued its guidance for the Solent area in 2019, and it's been through a number of revisions, and the current version is the 2020 version. And it sets out that the circumstances in which development is required to achieve nitrogen neutrality. It also says what's meant by this and how it should be measured and how it can be achieved. But in simple terms, and this is sort of the crux of it, nitrate neutrality requires that the amount of nitrogen entering the water system from a new development must be offset by the removal of an equivalent amount of nitrogen from the water system. So we're not adding any more to it by the creation of that new development. And the developer will most likely use this guidance by appointing an ecologist and getting them to carry out the calculations for their site and then reporting those findings to the local planning authority as part of its appropriate assessment. So once it's been established that a proposed development is not nitrogen neutral unless it can mitigate its nitrogen output, how does a developer go about mitigating its effects to allow planning to be granted? Now, this may be possible to achieve on-site, for example, where the development itself is taking place on land that already had a high nitrogen output, and the development use, so after planning, after the development's completed, would actually decrease that amount of nitrogen output. For example, if it went from agricultural to residential, then they could probably achieve it on-site, or they could do so through creating green space within that development or removing nitrates from wastewater before it reaches the system through the water system of that development. But in many cases, it can only be achieved off-site by using third-party lands, and that's obviously where developments have restricted in space and other constraints. And this is where we've been getting involved in work for our clients. So it's basically they use third-party land, like Rachel said about the banking, which I'll come on and explain now. So what we're currently witnessing in the Solent area is that sites are coming forward as mitigation banks, and this involves taking them out of agricultural production in advance of when the nitrate mitigation is required. And this creates a credit which can then be sold and allocated to developers to offset the nitrogen budget of their development as required. At Shoosmiths, we've developed a suite of documents that have been used to set up a number of these nitrogen bank schemes. The key document is a Section 106 agreement, and this is entered into between the landowner of the nitrate mitigation site and the local planning authority, and it contains planning obligations which ensures that the local authority can rely upon the scheme when they come to review an appropriate assessment under the habitats regs. The Section 106 agreement then sets out the mechanics by which the owner can then sell the credits on to a developer, and then this uses a standard form allocation agreement, which is usually appended to the 106, and this creates a contract of sale of the credit and then also provides proof of purchase of the credits to the developer, which the developer can then present to the local planning authority to show that they've secured nitrate mitigation for their scheme. It's worth noting as well that these off-site nitrate mitigation schemes can provide credits across authority boundaries. They're not bound by an authority boundary because the Natural England guidance relates to water catchment area that affects that special protection area rather than authority boundaries, but it may require further legal documentation to be put in place, such as a Section 33 agreement. I won't go into loads of detail about that now, but just to let you know that option's there, and we've been putting it in place for some schemes as well. So just to give you a couple of examples of ones that we've been working on. So one was a pig farm which had a high level of nitrate output and has been turned into a nitrate mitigation scheme by removing the pigs off the land, restoring it to by seeding the grass and planting trees and allowing it to rewild. Now, planning permission was not required for this scheme because it only involved taking land out of agricultural production. So there was a standalone Section 106, and that set out that our client could basically just needs to comply with the management plan to rewild their part of their farm and then maintain it for the lifetime of the development, so that developers can rely on the credits. And also keep a capacity monitoring report up to date, which kept track of the credits which they sell off to developers, because obviously it has a maximum capacity that can sell. The second example is a wetland scheme, and this differs from the pig farm. It was a dairy farm where they took it out of agricultural use, but they also then flooded part of the farmland so that more credits could be produced over a smaller area. And reeds were then basically seeded and grown, and the reeds filter out the nitrates, so it allows more credits to be sold off. And planning permission was required for the scheme because of the earthworks involved in setting up the wetland scheme. That's the end of my presentation. So we're over to some questions now. Rachel, I see you've got a few come in from Biodiversity Net Gain. So do you want to kick off with and run through those?
Yep, thanks Grace for that. Yeah, I've got a few questions here already, and some are sort of overlapping in terms of the theme. But I'll kick off firstly. So I had a question in, is the on-site or off-site provision an either or is there a preference for on-site over and above off-site? So as far as I understand it, there is a preference for on-site provision over and above off-site. I think the point to mention here is that the intention is for the mitigation to directly relate to and deal with the impacts arising from that particular development, ideally in the area and preferably to the actual site on which is located. So there is, yes, a hierarchy of sort of on-site provision in the first instance, off-site in the second, and then using the national credits system as a last resort. But no doubt we'll get more detail on this in the regulations after the consultation. Another question we've had in is, could developers in theory attempt to downgrade habitats on site prior to a planning application being submitted so as to reduce the baseline? That's quite an interesting question, and the short answer to that is no. Schedule 14 of the Act includes specific provision that allows LPAs to take account of any habitat degradation since, I believe the date is the 30th of January 2020, which is the date that the actual bill entered Parliament. And to use this date as the date for setting the baseline. So if there'd been any destruction of habitats which have taken place on site after this date, but the application, before the application being actually determined, the LPA would need to take this into account and look at the situation on the ground as at that date, so before any destruction works have been carried out. And they can use things like aerial imagery on or before that date to assist with this, to see what was there actually on the ground at that point. And I think DEFRA does also intend to produce some guidance on this in terms of exactly how that will work in practice. The next question I've had is, does every type of habitat which is reduced have to be subject to the 10% policy, or can a balance be achieved, e.g. linear habitats plus 50% or area habitats minus 10%? So my understanding is that the 10% requirement, once it's actually in force, should be applied to all areas, or each area, I should say, of habitats that are located within the red line boundary of a site. And you can't therefore say that, okay, we've created harm to one type of habitat, putting that, say, at minus 10%, but it's okay, we've provided 50% biodiversity net gain on this other type of habitat, and it has to be 10% across each different habitat type, or at least 10% for each. It could, of course, be more. I'll deal with one more question. So, in relation to outline applications and reserve matters, could local authorities ask for 10% biodiversity net gain at the reserve matters stage if the outline has already been issued prior to the Environment Act coming into force? So essentially, I think the question is asking about the relationship between outline permissions and reserve matters, and at what point is the percentage requirements decided. So I think, again, DEFRA consultation and the outcome of that should provide confirmation on this and how it will work. As a general point, however, the 10% figure, as I understand, will only apply to new planning applications which are submitted after the relevant sections of the Environment Act are in force. So if you've got an outline which requires a certain percentage biodiversity net gain, which could be less than 10% at the minute, in line with what the parties have sort of agreed at the time the outline is determined, then the local authority can't then seek an uplift to 10% at the reserve matter stage. So it'll be whatever has been determined on the outline that will be need to be complied with. Obviously, if there's nothing decided on the outline stage and it's all left to be dealt with that reserve matters, and that's a bit more of an issue. So I think actually in that sort of instance, we'll probably advise developers who are currently in the process of securing outline consents to make sure that a set percentage is included on the outline, just to avoid any issue of that sort of coming back at reserve matter stage. I'll leave that there in terms of the biodiversity questions. I don't know if you had any questions, Grace, on the nitrate stuff. Yeah, the time as well.
Yeah, we've got quite a lot of questions coming in as well. So if we don't get through all of them today, we can then produce some responses and circulate them by email as well. So just picking up a couple of the nitrate related ones. Can local authorities buy credits from nitrate banks as well as developers? Yes, so we have, so those nitrate schemes that I mentioned that we're currently working for the landowner who set up the nitrate scheme, they sell the credits privately to developers, and they also sell credits to local authorities who buy a tranche of the credits, and then they can either sell them on to developers, or they can recover the cost of them through a contribution in a 106 as you normally would. So that's that's not, we've seen that being done a few times. And actually, I think local authorities quite like that because it means that it can unlock a lot of development that's been on hold for some time as well. Let me see if I can find another nitrate related one. Can the legal documentation for nitrates be rolled out to address other environmental concerns? So I think Rachel touched on this as well with Biodiversity Net Gain. Obviously, we haven't put that into play yet, where it's not come in until later next year, or this year now even. We're now in 2022. But yes, we originally based our suite of documents on our SANG agreement. So if you've come across SANG, Suitable Alternative Natural Green Space, which basically deal with the adverse effect on special protection areas by recreational habits, that where developers are buying off-site parcels of land to be used as SANGs to mitigate the effects of their development. That's kind of what we use as the framework for the nitrate mitigation schemes, and then can also be rolled out to Biodiversity Net Gain when we need to do that as well. Let me just scroll through the... Oh, if nitrates are mainly introduced to the water system by intensive farming, why is it being controlled through residential development? So the simple answer to this is that the sewer systems don't filter out nitrates currently. The residential development is just, and the demand for housing is outpacing the infrastructure for sewage systems, and it's a bit of a quirk of the Water Industry Act, in that when a new development comes forward, sewage treatment centres facilities have to pick up that connection, and then obviously it increases nitrogen output into those high-risk areas. So it's just a case of where it can be controlled, really. Farmland has obviously been in place for quite a long time, and we don't really have the same scope to control it there now, so it's just through the residential system. I'll do one more. Let's have a look. It's just running out of time. How are the nitrate credits calculated? Yes, so that's all set out in the guidance. I've not actually had to delve into having to do that calculation myself. Most of the time our clients get an ecologist on board, as I mentioned previously, to help them through that calculation, and then the report is provided to and approved by Natural England once the ecologist has created that report, and that's how the scheme is set up. So then it will be approved by Natural England and then go to the local authority for approval as well. So we've only got a few minutes left, and we've got some really good questions coming in, so I think we will have to cover those off by email. Unless, Rachel, do you want to pick up any others, or Jill? I don't know if there's any on there in the last minute. Otherwise, we could hand back to Mandy to round up the session.
Yeah, if anyone else has got any further questions, do feel free to email panelists separately, and then they can pick it up with you directly. Thank you, ladies, for a really informative legal update. There's a lot of law in that, and the recording will be uploaded to the YouTube channel hopefully by the end of the week. Our next Women in Planning Lunch Bites webinar will be held on Wednesday, 16th of February 2022, and will be hosted by Thea Osman-Smith, who is a barrister from Number 5 Chambers and also a member of the West Midlands Committee. Tickets will go live next week. Thank you everyone for joining us today.